Good afternoon / good evening. Um, Kouri Richins was back in court today for a double hearing. Part was a status conference or scheduling conference, and the main part of it dealt with the notorious walk the dog letter, um, which was found in her cell during a search of her jail cell. And the other part of the here hearing was hello, Samantha. The other part of the hearing was on the um, civil case, which has to do with the probate of Eric Richards' estate and the lawsuits back and forth between Kouri and the estate of Eric Richins. So, um, just a quick summary on the estate issues while we're waiting for some people to show up. Um, Kouri Richins' business is not doing well. I didn't think it would. She was taking money out of Eric's account to kind of keep her real estate business afloat, and now she's getting foreclosure notices on the various properties that she owns, and so that's not looking good. Um, there was some debate on should she be able to get the life insurance, should she be able to sell off the assets, et cetera, et cetera. And the concern was, should she be able to use this in order to fund her criminal trial? Um, and the judge found that you can't really prejudice her against the sugars who've been targeted asserting. Oh ho. Aha. So let's see. He said, there's a real issue with taking away the ability to fund defendants' right to an attorney of their choice, but on the other hand, she's going bankrupt. So they kind of put everything in trust. Said, you can't sell any assets off. Um, so that's kind of where the things stay with the civil cases, and the majority of the uh, hearing, which everybody was there for, they had near capacity in the courtroom, was the motion to dismiss the case on the basis that she can't get a fair trial because the motion for contained the walk the dog letter, and that everybody knows about it worldwide. She can't get a fair trial. They can't find 12 people on the face of the earth who don't know anything about the trial. So therefore, Kouri Richins gets off. And so let me read a quick summary of the thing, and after that we'll watch the hearing. I'll play it on a 1.25 speed and stop periodically to comment on it with my observations on what the judge was saying. And I'm sitting there in the back going, what about this? What about that? And so I'll give you my thoughts on that as we go through. So this is the article written up by a CNN reporter, and says the trial against Kouri Richins of Utah, mother accused of poisoning her husband with a lethal dose of fentanyl, will proceed. Judge Richard Mrazek ruled on Friday. Richins faces drug and murder charges for allegedly giving her husband, Eric Richins, a fatal dose of fentanyl in a drink the night he died. The Richins attorney filed a motion to dismiss the case on the basis that allegations of prosecutorial misconduct over recent filings, which has become known as the Walk the Dog letter, for the words written across the top of the 6-page handwritten letter from Richins to her mother, Lisa Darden. So, yeah, it's very much like the burn after reading, because there's no explanation, no mention of a dog anywhere in the letter that I remember seeing. Okay, during the search of Richins' jail cell in mid-September, authorities discovered a letter with instructions for her brother to testify falsely, in quotations, according to the motion for no contact order. Prosecution asserted in their motion the letter allegedly contains instructions for Richins' brother to repeat a false narrative, in quotations, suggesting her husband had gone to Mexico to buy pain pills and fentanyl. In a separate memorandum filed by the prosecutors, Richins claimed that the letter was an excerpt of a fictional mystery book in which she and her father go to Mexico to find drugs. Sky Lazaro, Richins' attorney, argued prosecutors' comments in the filing said that her client was engaged in witness tampering, and her actions illustrate consciousness of guilt, though she has not been charged or convicted of attempting to intervene with the testimony of potential witnesses. The court simply isn't persuaded that the conduct of Summit County Attorney's Office violates the rule of law, said Mrazek. The court is confident that it can preside over a sufficient voir dire jury instruction and selection process to ensure that Ms. Richins does not, in fact, receive a fair trial, or does, in fact, receive a fair trial. The judge also ruled that third-party attorney will review material written by Richins to see if any attorney-client privilege exists, because it allegedly was contained in an envelope which was addressed to Sky Lazaro. That's my editorial comment. But just an aside on that. If that's the case, though, why would she be putting a manuscript on a fictional book in a letter to her, or in an envelope to her attorney? Because that's not confidential work product, and so that's abuse of the system. So anyway, let's get back to this. Prosecutors previously requested defense attorneys for Richins' share of the letter to her mother, as well as approximately 60 pages of writings in which allegedly a continuation of the Walk the Dog letter. The judge ordered defense attorneys to submit a form of order by December 1st on their proposed rules of engagement on how to handle the material. Once the rules and participating parties are set, the defense will hand over the requested materials to determine how attorney-client privilege, the judge said. Judge Mrazek also denied enforcing a gag order and contempt sanctions against prosecutors regarding the letter, citing that the arguments he made while he denied the earlier motions to dismiss. Prosecution's motion for a no-contact order between Richins and her mother and brother was also denied. The defendant has a First Amendment right to correspond with whom she pleases and to say what she likes, said Mrazek in the ruling. Eric Richins, 39, was found at the foot of the couple's bed in March 2022. The autopsy and toxicology results show he had about 5 times the lethal dose of fentanyl in his system, according to the medical examiner. Richins told investigators at the time she bought her husband a Moscow Mule into the bedroom of their Camas home, then left to sleep with their son in his room. She said she returned around 3 a.m. to find her husband lying on the floor, cold to the touch. Around a year later, around the year to the day after her husband died, Kouri published a children's book, Are You With Me?, about navigating grief and the loss of a loved one. So, yeah, the Michael Jackson stuff, but the Michael Jackson stuff was propofol, which is used in as an anesthetic kind of to so that the person doesn't remember what's happening in the surgery. So it just kind of completely puts you under. So let's see. We have let's see. We've got hearing queued up. Let me get that here, and we'll start that. And I might stop periodically to make some commentaries. So, because I definitely have some commentary. I'm just trying to sit on my hands and go, normally watching these things online, you can type what you're thinking, but, you can't exactly shout out in open court, well, what about this? So here we go.
I don't think so either. And here's why. If they had formally charged her, she would be given due process rights as it relates to to the alleged witness tampering. Right? We would be able to cross-examine people. She would get a trial. We'd be able to present witnesses. We'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witness tampered. This isn't the first time she witness tampered. This is further evidence of witness tampering, all of those things. And then they go on to say, not only did she witness tamper, but because she witness tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but that's the problem, and that's the violations of rules 3.4, 3.6, and the UDA standards. Is you can allege some through a filing or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes. Sure. Right? And she's going to get a preliminary hearing, and we're going to go through this entire process before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact, it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, if they charged her with it, you're right. But also then have the opportunity to refute that or go through due process rights. By just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witness tampered as a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse. So and they're tying all of this together.
A lot of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive. There was poisoning caused the death of her spouse. I mean, that's the case. Then we have requests for things like don't let her talk to certain individuals because, and then once we get into because, their justification for the request is we're concerned that she's trying to alter their testimony at a future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say they have a theory, right? It's in the probable cause statement. You can have a testimony of the detention hearing. You're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through. Okay? The problem is in their briefing, they dispel or they characterize the defendant's alternative theory or perhaps a potential theory of the defense as a false narrative, that it's a lie, okay? Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where any mean, we put up there, a jury pool for these people are lying. And the state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem. And the rules specifically prohibit the state from commenting on the theory of the case or on alternative theories of the case or on the credibility of witnesses. And
Trying to determine where the line between permissible advocacy and impermissible communications that would irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now. I'm with you. I got it. But why can't we, through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing?
I'm going to answer this in 2 ways.
Sure.
Okay, the first one is, I want to address first is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars, and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled,
But it was everywhere long before
it
this.
was, but it was everywhere before the state started making these comments. It was going to be everywhere. I'm not going to sit here and say that this wouldn't have happened or there wouldn't have been news stories. Sure, there would have been news stories about this case no matter what we did, and I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter, and the news stories have run with.
Accurate? I mean, I have assiduously tried to avoid news coverage of the case
Right.
just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I bumped into the cover of People magazine, which seems to indicate or have at one time been providing a counter narrative that seems to be provided by the defense side of the media.
I think there
Why
is a
isn't this a case of both sides airing their competing narratives to the fullest extent they believe is permissible under the rules?
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she told these people to lie about whatever it is, that's a problem. And I think that goes a step too far. Yes, we can all effectively advocate. We're going to do it through briefing throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility, I don't think, and then the narrative becomes, and the comments that we pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably gonna get some of those, but the state has taken it a step too far. And the other thing I want to address is there was an alternative method to this. And in the APA comments, this was the second part of your question, 2 questions ago, regarding, if they think she witnessed tampered, can they bring a motion and ask the court for relief? The answer is yes. Okay, I think we can agree on that. The problem is in the way they characterized it and the statements they make in their brief. The second problem is that it should have been, our position is it should have been done differently. And the APA comments speak directly to it, and it's 8-2 point. Let me get there. I can only remember so many numbers. Point 1. And what it says is a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order
in order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get a fair trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that. I think
Can we just acknowledge
Yeah.
that during trial, the options are so limited. The jury's already in the box. We
Right.
can't re-impanel.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases though that came back on appeal, right? Like it didn't get dismissed during trial. The conduct occurred, prior to trial, and those cases came back on appeal, for a new trial.
Those were embezzlement kickback side deal, right? Not pre-trial publicity cases.
Correct.
Am I right about that?
Correct.
Okay.
So I do think it's nuanced, or it's difficult in cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and in the statements they've made, have not done that. And the prejudice is we can't undo that. Okay, this letter is out there forever, right? Whether it's ultimately admissible at trial doesn't matter at this
It
point.
matters a little bit, doesn't it? Because if it were to come
I mean,
to
I'm
a
gonna argue it
trial.
matters because I'll probably move to most of it to suppress it, but
Well, sure. Yeah,
Right.
So, I mean, but I'm not expressing an opinion one way or the other
Right.
about any kind of motion in that regard. But imagine the letter came in a trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
the problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations.
Sure.
Right? And yes, we can get to that through cross-examination and
If it comes in.
at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that's the problem. The problem is their statements and the way they've interpreted it, and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, the way it should, in my opinion, the way it should have been done, or the state's, or the defense's assertion is they could have moved the court for a motion for no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument or in a way that wasn't the state saying that she witnessed tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems. And those aren't going to go away. Forever there's going to be this issue that the states said that. And they can't do that. And if the courts, and I granted dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue given the egregiousness of the statement.
So I looked at the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue yet. The dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find a jurisdiction that is, certainly not the state of Utah, that is going to be materially different than Summit County in terms of its saturation of media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this, so I do anticipate moving for a change of venue. Based on, I agree, unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court
not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else? Well, they've been involved. They're going to be subject to whatever ruling I make. I don't understand why this qualification of that office based upon public comments, conduct they take in prosecuting the case and making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now we know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why though on a going forward basis. What is it about the continued involvement of the Sunday County Attorney's Office on a going forward basis that would be prejudicial to this regime?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements. And I think that's a problem. Further, they've been involved in the investigation. Allow me a little more. Thank you. So, when they began investigating this case, I was having communication with some county attorney's office. So they've been involved since the very beginning.
Sorry, there were a couple of times where they had some glitches with the feed.
Of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's got to be a lie because it doesn't fit with our narrative of fact, right? The problem is, you know, there's an insinuation that perhaps they drove the investigation and this is where it ended up. And if it's, well, they made their ultimate conclusion in their briefing. Okay. And they were involved with the sheriff's office throughout the entire investigation. And they're saying that, you know, any alternative theory, say we, you know, go out and investigate and have investigators working and come forward with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, you know, maybe they go look for any. I think the implications of.
That's a great closing argument regarding the Richins getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Sunday County Attorney's Office.
I think in order to fix the narrative that the state has put out there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged is to say, you know, that they made mistakes, they violated the rules, and that we're not on the case. I think that puts us back a little bit to center where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that the
Isn't that problematic as well, though? Or are we sending a message? I mean, we have to exclude all the jurors that had any sense of that or draw any conclusions upon that. We need potential jurors that were agnostic about that. Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
Right, but there's still, I don't think without proper remedies from the court, it restores Kouri's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing, essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses, I mean, we're gonna call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world is taken that they're liars because that's what the state said. And they can't they can't make those, you couldn't make those in closing arguments. They couldn't get up there and say those things for a reason, right? So you should be able to say now.
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, Ms. Richins testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument.
Right, but it'd be based on evidence.
Fair enough.
Right?
Yeah.
And you could, that is, I mean, that's what you.
Just a little interjection here. The way that it's like, oh, they made arguments, and so it looks prejudicial because the motion that they filed makes the defendant look really bad, and and there's no way to remedy that other than to dismiss the case and to fire the prosecution team, and it's completely unrealistic. And what they're doing is they're arguing their point to try to get their point. I mean, because both sides they're under a gag order. They're not supposed to discuss the case so that we have pretrial publicity. So they are trying to do their pretrial publicity in motions and in arguments for the cameras and sound bites and so forth for the news, rather than news conferences and interviews and so forth talking on the thing. Now, this idea that there's no way that they can find a jury to, so that Kouri can get a fair trial because it's been seen all over the world. Excuse me, anybody ever hear of O.J. Simpson? He fled when he was supposed to turn himself in, and that was played out on the national news. People all over the world saw it. They managed to find a jury, and he was acquitted. Now, whether he should have been acquitted or not is another matter, but he was acquitted. So you can't say that you can't find a jury when you have, you have extensive pretrial publicity, because that's simply not true. Because O.J. Simpson was carried out live on national TV. It wasn't just a few stories, cover of People magazine, etc. It was live. And so, simply not the case. So, okay, let's go back and listen to some more. Oh, I do want to say that I really like this judge. He's got a lot of common sense, and he pointed out to her, there's never been a case that's been dismissed prior to trial because of pretrial publicity. That's always during the trial or after the trial. It's not before. So give it a chance.
Advocating closing arguments. You can say, we presented this, the jury does away the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Kouri through a lens that she's lying, to look at Kouri through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, I'm doing nefarious or criminal acts, is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out are materially prejudicial. And those are the things that they've done here.
I understand your position. It won't be the last time you get to talk. Plenty here from the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay.
Well,
Mr. Blood.
Good afternoon.
State's briefing was a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things the state would be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record. And that's an important point here is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing. The defense has an opportunity to rebut that case in the filing. They've just rebutted it, not only in the prior round, but right here, right now, at this podium. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will need to identify jurors that have knowledge of a whole long list of things, including the briefing, media coverage regarding the walk the dog letter, and the blood envelope, and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, who we can see as very impartial. Summit County Court said a jury is going to have to matter. They received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than Summit County. I can think of two pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see Summit County juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that I don't know if the state or the defense cites in its briefings, in dicta makes, I think, pertinent note that the publicity at issue in the prosecutorial misconduct and retrial motion was kind of a drop in the bucket to the overall publicity that the case received over the arc of time. That's where we are here as well.
Okay. Anything else from the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you.
Ms. Lazaro.
there are a couple of
Please.
with so the first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. That they're, essentially, what they say is it maybe doesn't matter, but this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by others in closing argument. What they can't say, and I think I'll pull out a few of the ones that I think are particularly problematic. they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want any more charges,
Right.
I agree with you.
But is it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're gonna focus on the top level charges that are in the information.
Absolutely, absolutely. And I don't,
So the only reason I raised that is to say, in that alternative universe that I am describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message. She's a witness tamperer. That is not different than we have here. It might be worse.
it might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say, or cross-examine people to essentially prove that that wasn't true.
Well, that's probably
So,
not to
and I don't
too
want
far
to,
in the
yeah, I
direction
don't
of
think that
why I'm
matters.
disinclined.
The issue is that they have just declared that she's guilty. Instead of,
Is there anybody in the world that thinks the state of Utah doesn't believe she's in charge?
is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used the way they've drawn the inference between witness tampering is that because she witness tampered is a consciousness of guilt. She induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt, why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, it's clear in the rules. It's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding.
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase consciousness of guilt in a number of different ways that doesn't say she's guilty of witness tampering. We're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, that's what you can't say. You can't go that far. Yes, there are probably a number of ways, but the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the APA standards essentially say there's different ways to do it. Like you could have done another seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, we're limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged, she violated jail procedure policy. As well, they make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative for the state's position on her guilt and the credibility of her witnesses. And I think I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you didn't handle the jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe these don't get litigated. I don't know. I mean, I don't know the answer to that. Maybe I don't know how many people, how many arguments are had. If this were a case without a lot of press, okay, if this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, you know, sure, we litigate things on the record, but nobody's looking for the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, you know, nobody would see it, right? The jurors, you know, I panel juries all the time that have never heard of my clients and have no clue about anything that happened, and you know, they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how majority of cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, you know, I have jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, I mean, obviously we're here asking for dismissal, but alternatively, without grave sanctions against the state. And we suggest that they be removed and to start over or continue forward, is what I should say, with a clean slate, in order to, you know, put some order back in and, you know, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing in a criminal case. It's, you know, the lofty reason a lot of us started doing this in the beginning, because we're going to be a champion for the rules. But and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. And a world that thinks that her liars and her witnesses and her counsel, you know, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
Thank you. Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements, rules 3.4 and 3.8 of the model and Utah rules of professional conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt with respect to certain explanations made by the defense for certain actions that no such link exists in the evidence. The defendant concocts a false narrative. That defendant's own handwriting, she attempts to induce her brother to testify falsely. That she is facilitating witness tampering and supporting a false factual narrative. That she is giving her mother instructions to induce her brother to testify falsely. That this may indeed not be the first time the defendant witness tampered. And that defendant is making a frantic, dishonest attempt to explain how Fendel came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by her credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate, so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions about the subject matter of this case or any of the people involved in it, parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge, and there was probable cause to bind her over for trial, and these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct of the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient voir dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied. All right. Any questions, Mrs. Lyon? Mr. Blood? All right. Let's move on from there. Let's go to the no contact order. The motion for no contact order. Mr. Bloodworth, you probably had this since when we last discussed this, but I'm disinclined to limit Ms. Richins' ability to speak to her mother and brother for several practical reasons. First, I've got to swim pretty hard upstream against the First Amendment to enter non-criminal case related issues that she probably needs to be talking to her mother and brother about, and those are implicated in many of the motions and issues cat's out of the bag. You know exactly what she's saying to them. All her jail calls are recorded. You have the letter.
Your Honor, let me take a second crack at it. We'll, in the course of this explanation, get the Your Honor, in a sense, the court has its hands on the dial. And if it turns the dial in one direction, it can amplify against witness tape. If it turns the dial, they're correlated, right? So if you amplify the protection, you're going to have a much broader prior restraint. And so when the state first asked for the no contact order, a lot of water under the bridge since then. When the state first asked for the no contact order, it asks for a lot of protection against future witness tampering, which also meant that prior restraint wasn't very notable. I think we're at point now, having all learned a little bit over briefing and argument before the day concluded. Based on where we stand now, the state would kind of adjust the dial, accept some risk of future witness tampering in order to more narrowly tailor prior restraint. And I recommend, to accomplish all of that, to include the necessary communication you referenced in your question. I think a more reasonable and appropriate order reads something like this: that the defendant shall have no contact with her mother, Lisa, and her brother, Ronnie, regarding the criminal case outside the presence of counsel. That would allow any necessary contact to prepare. That would allow necessary contact with her mother and brother to prepare her defense, but it wouldn't place counsel there to ensure that it was just preparing. Then the order would read: all contact outside the presence of counsel will be either through an in-person visit at the jail or through the jail's home wave applications text. And I say this because there is a monitoring component involved. The state is having to monitor the defendant to ensure going forward there is no witness tampering. And the state thinks restriction on in-person and texting allows monitoring kind of without gaps. We can get into monitoring hours of phone calls. There are gaps.
Status quo right now. The defendant in Summit County Jail is getting a notification when they make a phone call that it may be recorded. In-person meetings, are they notified that those may be recorded?
Yes, Your Honor, they are audio and visually recorded. The inmate and visitor are both notified.
And status quo, the inmate can't pass anything to a visitor, correct? Outside of counsel. We'll get to that in a different motion, but is that correct?
Yes, Your Honor, that's correct.
Okay. So why do we need to be so specific? It feels like the Summit County Jail is providing all the protections you need to figure out what's being said.
At a lot of time, I've been discussing this day, which is part of housing somebody. I appreciate that.
And prosecuting them, yeah.
And that risk that we're missing.
All right. Okay, I understand your position. Thank you. You get the last word. I'm sorry, Ms. Lazar, this one's ours. Just level with me. Do you think there's any part of this motion that I should grant?
No.
Okay. All right. Is there anything you want to say about it?
I think it should be denied, and I think that, I'm just gonna reiterate, the problem is the entire thing is premised on their accusation of witness tampering, which they have failed to prove.
Well,
I mean,
perhaps we can acknowledge that there are several plausible readings of the walk the dog letter.
yeah, if the court wants to.
One of the several plausible ones would be consistent with the state's version.
And one would be the defense's
Agreed.
version, and.
I guess what I'm saying is, why do I have to figure it out?
Well, you don't, and that's the problem, we shouldn't even have to. Like, that's the whole problem with all of this, is they're alleging a crime without any sort of due process, or without any sort of evidence to support it. And the fact that letter,
There's some evidence that a letter exists.
a letter exists, yes, but there's no indication in the reading of that letter that letter could be written in the lens of, these are the people who are gonna testify. I want them to remember these things, right? And that wouldn't be witness tampering. She can completely do that. Also, that letter was never passed or showed, and the inference that's made by the state is just because she held up one letter that she was going to do it with this one, and that's the problem. Like, they have not made a showing that even comes close to a probable cause finding for witness tampering. And I think there needs to be some acknowledgement, if the court's inclined to deny that there isn't a finding that happened. That's part of it.
I think it's probably more important for me to make no finding whatsoever on that, isn't there?
Yeah.
Okay. I understand your position. Mr. Leverett, issue before the court is the state's motion for no contact order that seeks an order preventing defendant from having any contact with her mother or brother to prevent further tampering with testimony. The state has narrowed the relief it requests today at oral argument to say that defendant should have all in-person, or request that defendant have all in-person meetings with her mother or brother with counsel present, and that other communications be monitored in specific ways through the technology available at the jail. First, the defendant has a First Amendment right and to correspond with whom she pleases and to say what she likes, as long as she doesn't do anything that requires prior restraint justified by a sufficiently strong interest that countervails her First Amendment rights. Here, there's no evidence that she's done any such thing that requires her to be prohibited from speaking to any specific human being. The Walk the Dog letters have several plausible readings. It does not indication that would typically justify a prior restraint on free speech. Moreover, there's no evidence that it was ever handed to anyone. And the state has it. So to the extent they need to cross-examine a witness or impeach a witness with its contents at trial, they would be able to do so, absent some other ruling by the court, excluding the letter or suppressing the search that found it. Moreover, the status quo is that defendant's communications with everyone, except her lawyer, are monitored. They're recorded. And the court's in no position to make that job easier for the state. So the court is simply not presented with a sufficient basis to restrain Ms. Richins' First Amendment rights. The motion for no contact order is respectfully denied. Okay. Anything further there, Mr. Wood?
No.
Ms. Lazaro. All right. Ms. Lazaro, the motion to enforce order for contempt sanctions, I sufficiently addressed that in reaching the conclusion on the motion for prosecutorial misconduct?
Yes.
Okay. The court is hereby denying the defendant's motion to enforce order and for contempt sanctions based on the same reasoning that justified the denial of the motion for dismissal based upon prosecutorial misconduct. Let's turn next to the state's motion to compel good cause disclosures. Ms. Lazaro, can I start with your team on this?
Sure.
Is it you?
Until I get a lawyer, it is.
There's a 60-page document. I have no idea what's in it. You You claim you assert it's privileged, correct?
I don't, there is a folder, or a manila envelope that Ms. Richins kept in her cell.
Right.
That contains a lot of pieces of paper. Okay. As far as whether a document, our assertion, yes, is that everything contained in that is privileged by way of, it was given to me, it wasn't given to anybody else, it wasn't published, it wasn't, nothing else was done with it. So yes, that's our assertion.
So the defense asserts that a 60-page or 60-something page document is privileged. The state asserts it is not, and is material to their case because, depending on which version of the explanation you focus
Just
on.
one thing really quick. How is a letter to her mother a privileged communication to her lawyer, because it's not addressed to her lawyer? And if it's a script or a fictional book on an alternate reality of what happens in her case, how is that a privileged communication with her attorney? Neither makes sense. And I think that we've only got her say so that it was in an envelope addressed to Sky Lazaro. And I would imagine that the sheriff deputies at the jail are wearing body cameras at all times. And so the search of the jail cell, I would think, is on body camera. And so if it came out of an envelope and if, X, Y, and Z, then it would show. The accounts we've heard is it came out of an LSAT book. It wasn't in an envelope. So just a little point here.
It reflects a partial factual, partial fictional narrative. Typically what we do is in-camera review and then allow the parties to make arguments regarding the content of the document and have a legal ruling about whether it is in fact privileged and subject to disclosure if it's not. You have access to the documents, so you're in a good place to make those arguments. I can't ask the state to argue about this with one hand tied behind their back. So, do we give the review attorney access to the document with a strict order that the review attorney cannot share any of the substance of the document, certainly not the document itself, with anyone from the state, and then have a sealed proceeding by which your team represents defendant's interests on this issue, the review attorney represents the state's interests, and then I make a determination.
We could do that, or we, as a team, kind of reviewed and discussed this. This kind of came up last minute, as far as putting it on today. And I guess I'll put this question to the court. Part is how you like go far enough. Part of our as it relates to privilege is how advanced to the content of the packet itself.
Well, but would you acknowledge that just putting a document in an envelope labeled attorney-client privilege and handing it to your attorney and no one else, that's not sufficient. If you put a takeout menu in that envelope and hand it to your attorney, the takeout menu is not an attorney-client privilege communication.
That's correct. It wouldn't be, but this isn't a takeout menu. These are her handwritten notes.
I'm so glad he said that, because just putting anything in an envelope, say an attorney-client privilege, is a great way to hide contraband. And, so like, let's say we've got some illegal drugs or something. All you got to do is stick it into an envelope saying attorney-client privilege and your lawyer's name on it, and suddenly, I can't get in trouble for that because it says attorney-client privilege. So, that doesn't make any sense.
I know, but I don't know what they say. So if they are in fact a fictional narrative where she's just writing a short story, I'm not sure the privilege at all.
Well, I think
But I'm also not sure the materials.
I was going to say, I think it needs before anything, whether it's reviewed by the court in camera or whether it's reviewed by Mr. Jordan, I think there needs to be a twofold analysis as to what and what not is privilege, and what and whatnot may or may not be relevant before it's terminated.
Without
I think
benefit
that's-
of advocacy by the defense and the state. And so I agree with you that if I determine that it's privileged communication, it does not get produced, no matter how material it is.
Correct.
All right, let me ask the state about this. Mr. Bloodworth, you see where I'm headed here procedurally. Any objection?
Your Honor, that's what the state asked.
It was unclear to me, though, whether you were asking for the review attorney to just make the call or have only the review attorney brief it. But what we need to be clear is the review attorney would have access to this, would be the state's agent, would represent the state's interest, but a branch could have access to the document or disclosure of its contents. And
Correct,
so I
Your
made
Honor.
the really,
Your Honor, I back off a little bit of what you said and say the review attorney is not the state's agent, he's a neutral. He was selected by the defense counsel.
not in my proposal. My proposal is that review attorney represents the state on this issue. Because Ms. Lazaro and her team are going to be making advocacy arguments on behalf of the defendant that I imagine go in the opposite direction.
Well, Your Honor, I imagine the state.
How? You want to know what's in the document. So you need a lawyer that has access to it, and it can't be a member of the litigation.
No, Your Honor, to some degree, the state does know what's in the document because the state has listened to jail calls where the defendant describes in great detail what's in the document. And that
Maybe,
is
but we have no idea if that description is accurate or not. The document speaks for itself.
correct, Your Honor, but how the review attorney interprets the document will depend on some of its characterization.
And so,
Say by the both the state and the defense can present your argument based on whatever facts they know as to whether or not particular material inside the envelope is privileged. And then he can make a threshold determination on privilege. And then once we're past that, then make the material determination.
it's not the way this usually works. Candidly, we're describing hamstrings on both sides. I'm not even sure it would be reviewable if we did it that way. Why wouldn't we just have the state designate, I imagine it would be outside counsel, who for this specific task is walled off from the state's prosecution team? When I represented members of the media, this is how we did it. Right? Like, we can't share any of this information with the reporter, but I can argue why they should have access to it based on the content of the document. Where do you see the error here?
Not at this. States are able to pursuing it in the fashion the court described. I've seen it work both ways. I think the what you described is more common in civil litigation context. To proceed, the state is fine to proceed in either fashion. The state's the thrust of the state's argument is the material needs to be reviewed by a neutral. The defense alone cannot make a privilege determination.
I don't disagree.
And whatever procedure the court prefers to accomplish that, stand
Okay, I appreciate that. Have a seat. There's a lot of chatter over there, Ms. Lazaro. You
Sorry.
feel like we need to
Yeah,
go a different
I mean,
direction?
just, I guess 2 points I'd like to make. Given that the court is doing
Email about that.
And I'm just bringing that up as, and like I said, it'll probably come up in argument, but, you know, they've already, you know, they have been proven. So.
I'm not sure what the significance of that is, but I don't know that I need to.
Yeah, we don't need to
right
get
now.
into it today.
Okay. All right, so,
Do you have a question?
no, I have some practical questions for the state. And if you're not prepared to answer them right now, Mr. Bloodworth, I understand I'm moving this issue in a direction maybe you didn't anticipate, but are you prepared to stipulate that the review attorney, Mr. Jordan, will be the state's attorney for the purposes of this walled-off review of the 60 whatever page document? Or do you want to designate a different lawyer and keep the review attorney separated for future tasks? Maybe
Your
not.
Honor, I want to consult with my team briefly on this, and part of the reason why is the review attorney is already engaged on other reviews.
Okay.
And so my sense is we need a new attorney.
Maybe so.
That I don't want any of his other reviews to
Be effective.
be affected.
Why don't we, we're going for about 90 minutes, why don't we take a 15-minute break?
Before we get there, can I just make one more point?
Sure.
I think before we get to the point of whether or not they're privileged or not privileged, we need to address whether or not we should be compelled to turn it over to someone.
That would depend upon materiality, right? I think that's right.
I mean, I think the
Hypothetical.
state needs to make a showing as to why they think they get this packet, first
No,
of
no, no,
all, right?
Well, all right, so let's put aside any issues of whether the way the document came to the state's attention is appropriate, should be suppressed, excluded. Put that aside. I don't have any motion like that in front of me.
Okay.
The state knows about it. They know some things that Ms. Richins has said that they think refer to the content of the document. Don't know whether or not they're accurate. We'll find out. Whether the defendant has to turn it over under Rule 16 will depend upon whether it's material, right? Whether there's good cause for disclosure. Hypothetically, if she's like, here is a timeline of how this went down, and just gives a list of admissions, and somehow it's not privileged, right? That's the kind of thing that would need to be. If it's, here is a short story about Care Bears, I'm not sure it's the kind of thing that needs to be handed over. Do you see the law differently?
Well, I guess in my mind, we need to go back a step. I mean, we're talking about whether or not things are privileged or not privileged, and then if they aren't privileged, whether they're material. Before we get to that, I think the state needs to provide a good cause showing as to why they think they get it. And I think it doesn't, before we ever get to any of those steps, like,
Well, I
why?
think they would say they have a sufficient threshold to trigger the privilege review based upon portions of the recordings of, if I'm summarizing that correctly, Mr. Bloodworth.
Yes, Your Honor.
So there's a reasonable inference in the state's view that the parts that are factual are backward-looking statements about what happened are factual. We'll find out. But there's at least enough that the state has presented to trigger your need to assert the privilege, maybe move to suppress, I don't know, and then to trigger the related materiality. Do you see it differently?
That's fine.
Why don't we take it?
Yeah.
If you need to get up and move around, that's fine, but it's 15 minutes. So if you don't want to get locked out, consider staying put. We'll be back at 3:20. Thank you very much.
All right.
A constitutional privilege, such as one against self-incrimination, an evidentiary privilege, such as the attorney-client privilege, or a counter-argument that you're wrong, it's not material. Why aren't we at that point where you're saying, for example, it's privileged, maybe additional privileges and arguments will be raised in the briefing that would occur behind seals, such as what they want would implicate Ms. Richins' right against self-incrimination, and or it's not material. That's what I'm trying to have play out through the adversarial process, and I don't know what's in the document.
Right. I think perhaps the state needs to make a good cause showing that they're entitled to it, I think, before we get to whether the materiality of it.
I think that's where we differ. And the reason I say so is, and and I'm happy to be educated about this, but State v. Spry, 2001, UT App 75. We further hold that the good cause, quote unquote, under Rule 16C requires the prosecution to establish only the materiality of the information requested from the defense before the defense is required to make such information available to the prosecution. But also that things like the right to be privileged against self-incrimination is paramount and therefore overcomes that good cause consideration. The state in its motion is saying, we think there's good cause here because based upon our interpretation of the content of the jail calls, this is a factual, partially factual narrative. Therefore, it's here. I don't think that that's true.
And if that's the court's position, they've only made that as it relates to the 60 pages, not the entire packet.
I agree.
So
Are we talking about the entire packet?
well, it was unclear to
Mr.
me.
Day says yes.
Yes, I was asked to turn over the entire packet.
Is that accurate, Mr. Bloodworth? I thought the briefing was I agreed to turn over the 60-page document, and then upon reflection, I
And
can't
then
do that.
it was further requested that I give the packet to the review attorney. And the problem
Did I
with that,
Mr. Mead?
It's okay, you're.
I
the
apologize.
problem with that is I can't, once I assert a privilege, I can't turn it over or I waive the privilege,
Understood.
and I can't turn over a part of it. So I guess what I need from the court today is an order telling me I need to turn over the 60 pages, if that's
No.
what the court's inclined to do.
No, I'm inclined to not do that.
Well,
So
am I,
let's-
do I
Let's
need
take
to-
a step
okay.
back. I understood, Mr. Bloodworth, that we were talking about the document, not the folder.
Your Honor, there's letter number 2.
That's what she held up.
Which is the one she held out.
Okay.
And then 60 or so pages of what she describes as the continuation of the walk the dog fictional.
Okay. Are those the two documents we're talking about?
Yes, Your Honor. We don't know what else is in there to make a good cause showing.
Well, that's the way it goes, though, when people are handing an attorney-client privilege or marked folder their attorney.
Well, yes, Your Honor, but when removal of material from the jail violates jail policy, that adds another wrinkle to it.
Let's stay focused on the two documents. I don't have enough to speculate about what may have been in or not in that folder, and now I understand the significance of Ms. Lazara telling me jail staff went through the folder several times. Now I understand where you were headed with that. Let's stay focused on just the two documents. The one page that was held up, which the vernacular for that is letter number 2.
The vernacular is letter number 2, Your Honor. It was multiple pages.
Okay. And then the 60-ish page document.
Correct.
Why shouldn't we handle those two documents in the way the court proposes?
I have no objection to that, provided that the court order me to give them to the review attorney or the court. I have no objection to those two documents.
Well, we're
So
going to
long
put an
as-
order in place first, identify who either the review attorney or the shielded representative of the state in this process is. And listen, I understand that normally the court would just review a document and make a determination about privilege. This case is very high stakes. It's an aggravated felony. It has enormous amounts of attention. I don't want to make this decision without the benefit of the adversarial process. So we're going to use belt suspenders on these. Have you determined, Mr. Bloodworth, who is going to represent the state in this process?
Your Honor, not by name.
Okay.
We can, but the state will select somebody in short order to serve as the state's advocate in this process.
I appreciate that. What I'm inclined to do is order counsel to meet, confer regarding the terms of an order that will control how this process unfolds. It states in black and white who is allowed to have access and not allowed to have access to the 60-page document and letter number 2, and then hopefully provide some deadlines for submitting the 2 documents to the state's shielded attorney and briefing deadlines for getting it before the court. Does that sound reasonable, Ms. Lister?
Yes.
Mr. Bloodworth?
Yes, Your Honor.
That is the state's order. Can you meet, confer on that within 1 week?
I am, yes.
Or
It's
no?
Probably not, actually.
Okay.
I'm gone. I'm going to be out of town working the majority of next week and I'm on vacation.
How much time would you like to get this sorted out?
Can we go to maybe the beginning of December?
By December 1, I need a proposed form of order or competing proposed form of order submitted to the court.
And just so I'm clear today, the court's ordering me to,
not disclose anything yet.
until you have.
Until the rules of this review are set, the participants are identified, those that cannot participate are identified, and that order is in place.
Okay.
Then everybody will know what they can and can't do. I think that's the appropriate way to handle this. Any objection, Mr. Glover?
No.
Okay. All right. That handles for today. The motion for motion to compel good cause disclosures. To be clear, I'm not expressing any opinion one way or the other about what's in this document, whether it's material beyond the facial, prima facie showing of good cause, or whether any other privilege would apply to it. I just don't know what's in it, and I need better briefing regarding the circumstances under which it was created, who was provided to. Okay. I think, Ms. Lazaro, Mr. Bloodworth, that brings us to conclusion on the motions that are pending in the criminal matter. Is that correct?
Yes.
Okay. Mr. Bloodworth?
Yes, Your Honor, to the extent possible.
Okay, and the rest of the hearing is just matters regarding the probate with the estate and the two lawsuits with the estate suing Kouri and Kouri suing the estate. And what it amounted to is Kouri's real estate company is the properties that she wasn't able to sell but had rented out to build up her real estate empire are getting foreclosed, which who could have seen that coming, since she was using Eric's money, looting his accounts to supplement her real estate business. So they ordered, and there was concerns about whether she should get the life insurance money so that she can use that to pay for her defense and so forth. And so basically the judge ruled that she can't go liquidating assets, and various monies needs to be put into a trust account until things get determined. So I don't really understand the intricacies of the real estate or the three civil lawsuits, because obviously those had been ongoing for some time prior to the first came on the radar with the arrest of Kouri Richins. So that was that. Let me see if I've got anything else in my notes. I spent part of the hearing in the courtroom, and I spent part of the hearing in the media room, and that was kind of interesting. Let's see. Oh, and it sounds like they're going to be having an overflow room to view in future. They didn't need it today, but it sounds like they're planning that as an option in the future, because I was afraid that not everybody would get in. And it seems that what you see in the shot there is most of the people that you see in the shot are from the Richins side of the family, and there's a little section which is over by the jury box, and that's the Darden side of the family, i.e. the defense. And they try to keep the two groups separated because there might be hard feelings, so it's just better not to. But you did have a little bit of overflow of Dardens into the back row, which was supposed to be reserved for general spectators. So let's see. Yeah, I wrote in my notes quite some time before he made the ruling. Judge is denying the motion because it was pretty obvious that that he wasn't going to dismiss the case, because that was kind of a ridiculous request, and it was pretty much just to get their side of the thing out into the media. So, and the motions to restrict her communication with her mother and brother was denied. And the judge pointed out that in the walk the dog letter, there isn't any threats in there, saying, if you don't do this, then X will happen. And it's a good point. So I do think that it was an attempt to mold the narrative. And a lot of this is kind of posturing, but on each side there. Since there's a gag order in place, they are trying to get their side out through filings and so forth. And that's happening with Delphi, happened with Murdaugh and so forth, that they will try to get around these gag orders by filings, and same with Ryan Koberger. So just kind of have to take a lot of what they say with a grain of salt. And the defense has to do it to preserve the issue for appeal. So if they don't do it, they can't go claiming it years later on an appeal if they didn't bring it up at the time. So we have Jim Brenner, also known James Brenner, has a hearing in Brigham City on the 13th in the afternoon, and I'll be going up for that. And I called and checked on Jared Lysick because I haven't heard anything about him recently. I mean, I've been checking because I had an appointment with the doctor to get medical form filled out, and I had to reschedule because the Jared Lysick hearing was going on. It was a preliminary hearing down in Manti, and preliminary hearing is the biggest one short of the trial. So I rescheduled the appointment, and the first opening was February. And so then I go checking the night before the hearing, and there's nothing on the schedule. So I've been checking every day or two to see if it's come up on the calendar, and it hasn't. So I began to wonder, has it been dismissed? Has it been has he taken a plea deal, and quietly it's gone away? And so the court clerk said that the hearing is December 29th, and I didn't catch the time, but since it's a preliminary hearing, I expect it's probably in the morning, which means I'll probably have to get a bed and breakfast room. I'm not sure if I'll stay in the one that I stayed in before, or if I might stay in my former childhood home in Nephi, Utah. Let me show that really quick, because it's a neat place. It's 44 minutes from Manti, and if the weather is bad, I don't want to do that because it's a 2-lane road. Let's see. Okay, This is the house that my family moved from Alaska to when I was into kindergarten, because they were going to demolish the home to expand the car dealership next door. And when I lived there, the entire front yard had cars and an awning in it. And so you couldn't really see it, but we prevented the house from being torn down. And the people who own it now are running a bed and breakfast out of it. And they managed to track me down through a dollhouse group because I posted about it. And so if it looks like the roads might be good, I might possibly stay there with them instead. So we'll see. I'd love to do that because it's such a lovely home. My bedroom was the one on the left upstairs. The turret was my sister's room. So fond memories of living in that house. So yes, it is. It's a lovely place. And I might do something on it sometime because Ghost Adventures was saying that the builder of the home was a killer. And so I need to do some material on that sometime and tell the story about the owner of the house being a killer because he was elected state senator. So I had a hard time believing he was really a killer, and he was the town banker. So it's good to see you, and thanks for joining me. So next hearing, Jared Lysick on the 13th. And there's another case that I would like to follow, which just came down. This pilot, not the guy who did the magic mushrooms, but another pilot, I guess, in flight. He was on the flight crew, and he threatened the pilot of the plane. So this is like the secondary guy in the cabin, pulled a gun on the captain and said he would shoot him if he diverted the flight to land because of a sick passenger. And so that's a federal case, and I need to check in and see when the arraignment is on that, because I thought that would be a rather interesting case to, because you don't hear about the flight crew pulling guns on each other in flight. So I will try to get to that if I can find out when it is. So thank you for joining me, and hope you all have a great night or day or whatever it is in your part of the world. And the state is probably going to be wrapping up the case that I've been streaming with Jesse Kaczynski. And so Monday, I wouldn't be surprised if the state wraps up with that. So thank you very much, and we'll see you soon. Bye-bye.